Yep.
That
That's Kate.
Okay, everybody, let's just talk generally for 5 minutes because Michael Kelly's on the highway en route. Yay. Does everybody know who Michael Kelly is before he walks in the door? No? Where you might have seen the name in some of the opinions that you read. Michael Kelly. And I don't always, I sometimes redact mostly, and in the casebook that I gave you, I sometimes redact. Sometimes I leave them in, like, I left Judith Wolf in, so you could all see her in one of the cases. I forget it was the Isaac or Jeremy, one of those. Anyway, Michael Kelly was the attorney that actually brought the Robert case that set the standard of preponderance of the evidence to the SJC. He's also very involved in the Chin's cases, so he'll be coming to talk about Hillary and Angela in those cases. So again, both at the appellate level, he's involved, and at the trial level, he's been a practicing attorney. God, I think I probably met him in the 80s when again, most of the juvenile courts were the juvenile sessions of the district courts. And he's been an attorney for parents as well as children. He's very engaged. He participates in the mass seal, the continuing legal education conferences that we have in various aspects of juvenile law. As I said, he takes appeals and successfully argues them and gets the SJC to change the law, basically. And he's a little soft-spoken. So I might end up moving to the other side of the room just so I can get him to, Karen's nodding her head because she's a jail and she's met him before and seen him before. That's the, yeah, very, very soft-spoken, but a wealth of information. But until he comes, okay, so CHINS, what is CHINS?
Child and Youth Services.
Oh, good. We got that part right. Okay, so basically there are 4 ways that a child gets into the system on the CHINS petition. Somebody give me one. Joe?
They run away.
A runaway, okay. And who's the petitioner if it's a runaway?
One of the parents.
Okay. Karen?
Truants, or, not being in school.
Not being in school, truant, and who's the petitioner?
School.
Okay. Steph? I mean Geneva. I'm doing it again. Geneva?
No, I was gonna say.
You're gonna say truant? Okay, give us another one.
Yeah. Another if they're acting out in school, so not running away.
Acting out
but
in
acting out
school. Yeah, and I mean we'll look at the proper words of the statute.
Or disobeying their parents.
Disobeying it's in terms of the school, it's disobeying something like, and I'm going from memory myself, somewhere disobeying the lawful regulations of the school, basically. Okay. And as Karen mentioned with the truancy, the school's the petitioner. And then the 4th is?
I think they call that habitual school offenders.
Yeah, at times, and that was the early history, habitual school offender. And the last one is the?
Through a care and protection case.
Parent. A parent. So those are the 4 ways. Guys, here's Michael Kelly. Hi, Michael.
Hello, Professor. How are you?
Okay, nice to see you. I told them you're soft-spoken, so I'm sitting on the other side of the room.
I can speak up when I have to.
Yes, he can. I don't know if anybody's coming in over here, but I'll sit in one of these chairs. Oh, Amy might. If she does, I'll move down. Oops, sorry.
What I've done before when I've come to this class is that I have written down little thoughts about what's happening in Massachusetts juvenile and probate court, mostly juvenile court, so that you will have a sense of what some of the current hot topics are. I have enough there. Because otherwise, I mean, you can ask me a lot about the different cases that I've had. You've probably read a few of them. Some of the cases that I've litigated, especially the appellate cases that I've litigated. But that, for me, and I think for you, gets kind of boring. So I think it's a little more interesting if I can tell you what is going on in Massachusetts right now. If any of you are from New Hampshire and tend to practice in New Hampshire, things are a little different up there, but then things are always different between Massachusetts and New Hampshire. So the little bit I know about New Hampshire we can talk about, but Massachusetts has its own way of doing things in juvenile court, and I think that there are prospects for change in some of them, and there are new laws that already have been put into place recently that I thought it would be interesting to talk about a little bit. Have you covered Chin's law yet?
Today's the first day,
Okay.
so in essence they haven't. They've
Okay.
done some reading for
Okay.
this.
So we could talk a little bit about chins because a lot of these things have to do with chins. Chins is, when you talk about juvenile court in Massachusetts, again, every state does it slightly differently, but the juvenile court in Massachusetts handles all juvenile delinquency and youthful offender cases when kids under 17 get arrested. I think one of the things I forgot to put down here was that there's a push in Massachusetts to raise the age of juvenile court to 18. And many states, including Connecticut recently, have made their juvenile court go all the way up to 18. Massachusetts, for years and years and years, since prehistoric times, has been 17. So that if you get arrested on your 17th birthday or the day after that, you're an adult. You go to adult court, and you are too old to have your case heard in juvenile court.
Mike, is that pending legislation?
That's
on the
pending
18th?
legislation. Who knows whether it
Right.
will ever get adopted or not, but there is some momentum behind it. So I think there's more of a recognition that kids are different, adolescents are different, teenagers are different. You probably, in the course of your class here, will talk about a lot of the U.S. Supreme Court cases that have looked at that recently as to how adolescents are different. And so there is talk about raising the age of juvenile court to 18. The other kind of case the juvenile court does is care and protection cases, obviously where the state gets involved in a family.
And they just finished that.
Yeah, tries to take kids away from their family and everything. And then the third kind of case, which is, in terms of numbers, a fair number of cases, is what's called chins cases. Those are called status offenses, because kids are brought to court for things that, if they were an adult, they could not be brought to court for. So it's their status as a juvenile that brings them to court. They're either not going to school, running away from home, or not obeying their parents or lawful guardians. Once they turn 18, they can't be brought to court for those things anymore. So it's their status as a juvenile and the fact that they're allegedly doing these things that allows a petition to be brought in the juvenile court. The theory of the reason that the court is involved is that the child can get help, the child can get services. That theory was never all that successful because of various reasons having to do with finances and budgets and services and the state child welfare agency and different things. So there's been a lot of talk over the years about changing the chin statute. Problem always is that you have many different camps with ideas as to what to do with chins. There's one camp that says do away with it entirely, it doesn't belong in the court, it's stupid, it's a waste of time for judges and probation officers to be involved in this kind of thing. There's another camp which says that chins should be beefed up, given more teeth. The court should be given more power to deal with the kids and the families and the parents, and the kids should either be able to be locked up or forced, help down their throats if they don't accept it. And so whenever it goes before the legislature, those two camps kind of fight it out, and there's no consensus. There's no clear path as to what to do about chins. Recently, some legislators did get together and with kind of taking the best of both of those thoughts and created a whole new chins type law. It would do away with chins, and it would, I think it's called FACES, Families and Children Engaging in Services, some stupid acronym. And that law passed the state Senate unanimously, but has gone nowhere in the House in Boston, in the State House. So who knows if chins reform will ever happen. The theory of this new law would be that most chins would be diverted and would be get more services and would not have to go into court at all, and only the most serious cases would have to go to court. So, but the court would be able to do more with the cases that did go to court. So it's, in a way, a combination of the two camps' efforts, but who knows whether it will pass. Maybe midnight, July 31st or June 30th or whatever the current session of the legislature is up. Maybe they'll pass something. You never can tell. The other thing that did come down in chins cases recently, which you'll probably read about, was the decision of the SJC a few years ago in matter of Hillary that decided that indigent parents in chins cases can get court-appointed lawyers to represent themselves because they could lose custody of their children in a chins case. The children can be placed in the custody of DCF, and so in situations where that might happen, the court will appoint a lawyer for a parent to request. Any questions about chins cases?
On the Hillary case, just because the students in here, and so for the most part are new to chins, and I guess I just want to be clear about how that case has such precedential value. In other words, how so for many years we practiced virtually with parents being involved but not really as parties to chins, and how big a case Hillary really is.
Yeah. Well, I think it's part of a line of cases that have recognized how important parents are, how important these kinds of cases are, and what effect they can have on a child and on a family. The best example is the truancy case. Child hasn't been going to school. School goes to court, files a truancy case against the child, supposedly, but the remedy is the only thing the court really has to do, if nothing else will solve the problem, is to take the child out of their home and place them in some kind of other care situation, whether it's a group home, residential school, foster home, something else. And that has great impact on the child and on the parents and on the whole family. And so I think there was finally a recognition that that kind of involvement in a family's life needs to have the protections that you have in other kinds of cases, like care and protection cases. And a lot of times what really needs to happen in those kinds of cases is some school, special education involvement, something, and so a lawyer for a parent can get into the school and can try to make something happen there and maybe alleviate some of the problems that they've and it follows a few other cases that brought changes in chins. I'm sure you'll talk about Matter of Angela and a few others like that that have caused chins to be hopefully treated a little more like legal cases and not like just social work that happens to pop up in court every now and again. My notes here are not necessarily in any order. I probably should go back next time and order these more under different topics. But one of the things that is always being looked at is the extent to which there's disproportionate involvement of minorities in juvenile court in all kinds of cases. That children of color are more likely to be arrested, more likely to be brought to juvenile court, they're more likely to be involved in the child welfare system, they're more likely to be placed in foster homes. I haven't seen any statistics on chins, but basically there appears to be a disproportionate minority involvement in juvenile court in all kinds of cases without reason other than the race of the child and family. And so part of what they've been trying to do in Massachusetts is just get good statistics, because sometimes the statistics are very hard to come by. So the legislation in particular that may pass the State House would just be requiring all the different parties just to keep better statistics so that they know the extent of the problem and can try to attack it that way.
Excuse me, do you think there's an economic kind of nexus in that?
I'm sure there is. I'm sure there is. But when they tease out the economics, then it doesn't explain everything. I'm sure it's a big part of it, but it doesn't necessarily explain it completely.
And
it's
Michael,
hard-
that's
no
in
way it is.
detention as well as
That's in detention.
cases in juvenile court, right?
Cases in juvenile court, right. There have been improvements in Massachusetts in terms of the services for children who have mental health problems. There was a class action lawsuit in federal court saying that children on mass health getting Medicaid were not receiving the proper mental health services, and the federal district court so found and ordered the state to provide better mental health services for children on mass health who are getting Medicaid and who are supposed to be getting good mental health services. This has led to the formation of community service agencies, CSAs, which are providing these better services. Anyone interested in this, if you Google health law advocates, they're an advocacy group in Boston that fights for mental health services, and they have a children's project, and they actually have a project where they can be appointed guardian ad litem in juvenile court in cases where mental health is really an issue, to try to get mental health services for children, and made a lot of difference in a lot of cases. So if you go to juvenile court or probate and family court for that matter and see children who are in real need of mental health, often you'll see these services involved. And
Who pays the GALs? Do they get
There's
paid?
a grant. I think there's a grant. They actually work for health law advocates, and I think health law advocates pays them through some kind of grant. Yeah, it's a big problem, as we'll talk about later, budget problems. There aren't GALs, there aren't ways to get money from the court anymore as much as there once was. So this is an effort to help that, but it's done. In that case, it's done by a grant. There also are some GALs that might be like law school clinical programs that come in as GALs and different things, and so people have had to get creative in how they get those services into the court, because the court doesn't have a lot of money anymore to do those kinds of things. Speaking of detention, there's been a real effort by DYS, Department of Youth Services, to cut down on the use of detention for kids, recognizing that the state was spending a lot of money to detain kids who probably didn't need to be there. that it wasn't good for the kids, it wasn't good for their families, it wasn't good for the budget of the state. So the DYS has been looking into alternatives to detention and keeping the use of detention down pretty well, and saving a lot of money there and using that to beef up some of their other services for kids. So that's something that's been pretty successful and is ongoing. One of the things that is a new law that was passed, signed by Governor Patrick, and is fully going into effect in May, is a total revamp of the Corey system in Massachusetts. In all the ways that criminal offender record information is used for jobs, for the courts. The system is totally being revamped, and it includes more protections for juveniles and how their Corys can be used against them in the future, and when things can get sealed. Massachusetts is not a state that does expungement at all. Many states, when you become an adult, they expunge your juvenile record and totally do away with it. Massachusetts has never done that. Doesn't seem to be in the prospects that Massachusetts would ever go for that. So your record stays around for the rest of your life. So this was an attempt to make it harder for people to get at it, less need for people to look at it, and ways that you could seal it.
So in what ways would it be more protected?
There would be less categories of employers and people who would be able to have access to your record, less need of you to divulge your record when you're applying for jobs, making it easier to seal records, making it, you don't have to wait quite so long to ask them to be sealed. The crux of that law really applied to adults, because there was a recognition that adults who had even the most minor of records were being denied jobs, were being denied opportunities, and it was very hard in Massachusetts to do anything about that. So this is an attempt to make it a little bit fairer, and all of that is going into effect in May. So that's a good thing for you to be aware of and to look up, and to, because oftentimes we as lawyers are asked to help people out, either help people to seal their records or find out what their records are, or give assistance in that respect. And if people are going for jobs and they sign off and say, yeah, you can check my Corey, and then all of a sudden they're denied for stuff, sometimes it's weird little things that happen when they were juveniles or young adults that.
So will kids in the future, will they be more successful at getting, typically you have kids that say, I always wanted to be a cop, you know, and I can't because of my juvenile record.
Hopefully, yeah. Hopefully they would be easier to seal their juvenile records, and things would not be able to be used against them in the future.
I thought, excuse me, I thought the whole idea of having separate juvenile courts and things so that they wouldn't have records.
That's
Like
the
a kid.
idea.
That is the idea, Leslie, I know.
Right, didn't we learn that from like day one?
Yep. But Massachusetts didn't implement that idea across the board.
Yeah.
There were these weird little provisions, especially when it came to Corys, and when you have kids that were, and sometimes it was done thoughtlessly.
Yeah.
They might have put in a new law for sex offenders, or for allowing camps and hospitals to get access to Corys. And a lot of times the legislature would not say, does it just apply to adults or does it apply to juveniles too? And if it didn't say, the courts might say, well, it looks like it applies to everyone, so we'll apply this to juveniles. And so if you're applying to be a counselor at summer camp, they can get your juvenile record. If you're going to work with kids in a daycare, they can get your juvenile record. And there was no way to expunge it, no way to seal it. All of the very draconian sex offender rules apply to juveniles. So if you're, and there are just some horrific examples. In Massachusetts law, as it applies to kids having sex, is not very good anyway. So two 14-year-olds who have sex with each other can both be convicted of statutory rape. And other states have laws that there has to be some difference in age or some difference in relationship or something like that. So, and then, so someone who then gets convicted of statutory rape has to register as a sex offender. And all of the draconian things, and wear a GPS on their ankle for the rest of their life almost. It's really bad.
In relation to the statutory rape, isn't it true that when, say, the 14-year-old and the 14-year-old are convicted, it's the parents that bring those charges or bring it to the attention of the ADA?
Often. It could be a school, though, that finds out, or it could be a child having a baby when they're too young.
And the
They find out who
child
the
doesn't really
father
have
is.
anything to say, right, about it?
They might have a little bit to say. I mean, they might refuse to identify who the father is or who the mother is, but they have, they may not have a whole lot to say. They could theoretically refuse to testify, but there may be other ways that it can be proven, so it's hard to know. And I mean, not all those cases get prosecuted, but when they do, they can be very difficult for everybody involved.
With sealing the records, would there be standards? So if you did do a heinous sex offense or something like that when you're a juvenile and then you are applying to a summer camp, they would still be able to get that. But if you were applying to maybe some other job that had nothing to do with children, those people wouldn't be able to get it?
Yes.
Okay.
There are different categories of jobs,
Oh.
different categories of employers. Things like summer camps, hospitals, daycares who have children and vulnerable populations get more than other kinds of employers. Yes, very much so. And there's more of an effort in the new law to treat minor offenses differently than major offenses. And it just makes the whole scheme a little fairer as to how it's applied. It's not perfect, but it's a lot better than it was.
Question.
Yep.
But even if your record is sealed as a juvenile, that sealing still exists, so true, is it? I mean, this won't get
For
rid of
most employers, if your record is sealed, the Corey board will tell the employer you have no records.
that. They won't say that it's.
They won't say that it's sealed.
So when you say most,
I think pretty much all employers. I think the only people who find out about sealed records are the Department of Children and Families if you're applying to be a foster parent or an adoptive parent. They find out about sealed records.
Board of bar examiners.
Board of bar examiners. Applying to be a lawyer. And maybe the judicial system might find out if you have a record that's been sealed, but it's very narrow as to who finds out about a sealed record.
I don't mean what is contained in the record.
Right.
But that there's
Just the
actually-
fact that there's a sealed record
Does-
is not divulged very much. It's divulged to only a very narrow list of agencies. Because otherwise it won't help. Yeah.
And that's for juvenile only.
That's for juvenile and adult.
And
Adults too. Yeah. Yes, and that, the new Corey law made that a little easier to do. You don't have to wait quite as long to seal a record, and made those protections a little stronger.
So I've heard though from other sources that sometimes it's not, as a juvenile especially, you don't necessarily want to seal your record if it is for a minor infraction.
That was very true under the old law, because
But-
that was more, divulged more. I think we have to see how the new law will work, but I would probably advise people under the new law to think about sealing more often, because I think it will help people a lot more than it will in the old law. And the only time that I've seen it be really sticky is people who are applying to be foster parents or to adopt a child through DCF. DCF doesn't like sealed records and goes crazy for no particular reason at all. But other than that, I think the new law will be better in terms of sealing. That's what it seems like. We'll have to see how it plays out in actual practice. It hasn't even gone into effect yet, so it goes into effect next month, so we'll have to see how that works. You probably have talked about bullying, harassment. There's a new anti-bullying law making schools take strong action against bullying, helping the victims of bullying. And separately, but around the same time, there was a new law passed which allows people to file for harassment protection orders, very similar to 209A domestic violence orders. But there was perceived to be a hole in the domestic violence 209A law in that in order to get a 209A, you had to have a dating relationship or a family relationship where you had to live together. So if someone was stalking you who didn't fall into any of those categories, you could not get a restraining order against them. And if someone was bullying you or harassing you, very little you could do about it. So this new harassment restraining law allows the court, if there's been 3 or more incidents of harassment, you can go to court and get the equivalent of a restraining order against the person who's been harassing you or bullying you or whatever.
When did that go into effect?
That went into effect about a year ago.
258E, it might be a couple of years by now, maybe. And it's for adults as well as
Adults and
juveniles.
juveniles, and if the parties are both juveniles, it has to be done in juvenile court.
Right.
So you see middle school students, parents trooping into court when they're being bullied, or when one side is bullying the other, or vice versa, getting these harassment orders. And they present interesting issues for the judges and really interesting issues for the schools, because what happens if you have kids who are in the same class and there's some bullying going on and they run to court, get a harassment order, and now the school has to keep these kids away from each other. So it's a very interesting law. We have to see how it will, again, with any new law, we have to see how it will play out. But it does cover some of the gaps in the 209A law. So there certainly was a need for it, but whether it was too broad and whether it has, all laws are wonderful in theory, but it's the unintended consequences of laws, things that you may not have even thought about that come up when you pass a new law. That's why there's work for all of us as lawyers and as law
But
students.
counsel don't get appointed, right, on the 258Es?
Counsel do not get appointed. Okay. They're not criminal, they're civil.
Right.
Same as the 209A, anything
Mhm.
else. The only time you'd get appointed is if someone was accused of violating it.
Okay.
And they were brought up on the crime of violating a harassment restraining order. So that's a very interesting new law. A lot of the work that I do, whether it's in a juvenile delinquency, a CHINS, or C&P, is representing my students who are being threatened with suspension or expulsion from school. If they bring contraband into school, drugs or knives, if they assault their teachers, if they are arrested for a felony, they can be expelled from school. And so entitled to a hearing with the principal. If you don't like what the principal says, you can appeal it to the superintendent. And a lot of, so I spend a fair amount of time defending students, trying to keep them in school when the school system is trying to kick them out. Colloquially, around the country, this is such a big problem that people have referred to it as the school to prison pipeline, because kids get in trouble in school. Sometimes they get arrested in school for disturbing a school assembly or committing some heinous crime in school that kids would normally before just have been dealt with in school, but now they're brought to court, charges are brought against them, they're found guilty, they're put on probation, they violate their probation, and then if it's bad enough, they ultimately get committed to DYS for doing things in school that the school, if they were better funded or better thought through, the school would deal with these things. So there's some attempt to push back on that and to keep these cases and kids out of court, out of prison, and make the schools deal with them in a better way.
So do you get involved while it's still on the school level, or is it when you get involved?
It has to
already
have been involved in court somehow.
somehow? Okay.
But sometimes it's the court involvement that lets the school take action.
So there could either be a chins or a delinquency or both.
Right.
And Mike would be
Or
appointed.
it might be a child who I represent on the CMP, say they're taken
Right.
out of their home, they're put in a residential school or a group home. If they have some kind of problem there, then I might go help them there. But in order for me to take it on, unless I get hired privately by the
By
parents,
parents, yeah.
I had to have been appointed by the court in some court case in order to take that on. But I think a lot of kids, a lot of parents go to these kind of meetings without lawyers and
Yep.
have to deal with it somehow, unless they can afford to bring a private lawyer. There were a lot of really interesting cases in the U.S. Supreme Court recently having to do with juveniles. There was a great case last year, North Carolina versus JDB, looking at interrogation of juveniles in school. The case that was argued just a few weeks ago, I think, was the
Yep.
case of the juveniles
Yeah.
convicted of first-degree murder and whether it's cruel or unusual punishment to lock them up for the rest of their lives without any chance of parole. So there's a big
This case,
national.
yeah, two companion cases,
Yeah.
Miller v. Alabama, I think.
Yeah.
And I forgot what the name of the other one was.
There's a big national campaign to do away with juvenile life without parole. It'll be interesting to see.
And by the way, Suffolk Law School is doing a conference on April 20th. It's a Friday, from noontime till 2, if you want to check the website. It looks like, I mean, of course, us attorneys are going, and it's really cheap for,
Right.
it's $35.
Right.
People like Mike get 2 CLE credits for it and whatnot.
Right.
If anybody's interested, I believe the law students can go.
Oh, yeah, anybody can go. Yeah, it should be very interesting. But it talks about juvenile life without parole, but it's also just talking about how, again, how juveniles are different. There's been several cases recently in the U.S. Supreme Court, Roper and Simmons, and a few other cases where the U.S. Supreme Court has finally recognized that we treat juveniles differently than we treat adults. And so you can't lock up juveniles for the rest of their life for committing things that are not murder and different things like that.
You said that they had just heard the arguments on that case?
Yeah.
Supreme Court,
The
yes.
Supreme Court,
Yeah,
so they haven't
yeah.
come out with a decision
No
yet?
decision
No,
yet.
no.
Probably in June, along with the health.
And you can
care
access
decision and
the
everything
oral
else.
arguments.
Yeah.
Yeah, yeah. A lot of interesting cases they've heard the last few weeks. That was one day they spent hearing those cases.
And did you say, Mike, that there's also pending legislation regarding the life without parole?
There is.
No, actually, I saw that on the Suffolk brochure.
Yeah. Yeah, there is,
Trying to
and there's a
change
campaign in
265.
Massachusetts to try to change And because first and second degree murder cases are not in juvenile court anymore. There was a horrific murder case in Somerville about 20 years ago, Eddie O'Brien, who killed a neighbor. And because it was perceived that the sentencing for juveniles who commit murders was so lenient, the law was entirely changed. And now in Massachusetts, anyone who's under 17 who is charged with first or second degree murder, their cases basically go automatically to Superior Court. And if they're found guilty of first degree murder, there's a mandatory sentence of life without parole.
So you have the recent case of, and I forgot his name, the child who knifed the other
Knifed the
out
other
of
student in the bathroom, right.
Yeah, Sudbury. What was his
Yeah.
name? He's doing life right now.
He's doing life without parole, right?
I just forgot his name.
Yeah, I forget his name.
Had
Asperger's.
Asperger's syndrome. Yeah.
So that's an issue that is currently hot. The courts in Massachusetts and in many other states since 2008 have had tremendous budget problems, so that one of the things that we have to deal with is that there are fewer people working for the court, fewer probation officers and clerks, fewer guardian ad litems because the court can't pay for them. DCF has less money, DYS has less money. In the midst of all of that, the bar advocate system, where private attorneys like myself are appointed to represent people in court, has come under fire from the district attorneys and from the governor as being too expensive. And so their great idea was to take these cases away from private bar advocates getting
Who have been doing these
getting
cases
the
for
princely
years.
sum of $50 an hour and give them to full-time public defenders that are going to have pensions and health insurance and everything else. So if you can get one of those full-time public defender jobs, more power to you. Apply for them, try to get them. But those of us who like doing general practice and do public defender work as part of it, the current effort is to increase the percentage of public defenders from taking 10% of the caseload, and now they're trying to get it up to 25% of the caseload across the board. Governor Patrick, in his budget for next year, wants to get that up to 50%, but it seems unrealistic and costly and everything else. But in the midst of all of that, one of the things that the courts are doing now is cracking down on figuring out which people really are indigent or not, which people really are poor or not. And so people who come to court for the first time are being interviewed very closely about their income and assets. And the court is actually setting up direct computer links to the Department of Revenue, to the Department of Public Welfare, and verifying everyone's income and assets and making sure that they really are indigent. And if you make a misstatement to the probation officer, you can be fined $1,000 or charged with perjury and all sorts of other stuff. So, and one of the side effects is that they also are checking people's citizenship a little bit more and sending some of those forms to ICE. And so there's some odd immigration consequences to this as well. So if you see people going to court and having to bring in their tax returns and their whole, it's like amazing. But they are attempting to crack down on who actually gets a public defender. A few years ago, the guardianship law was totally revamped, including the guardianship of minors. the law really didn't change that much. It mostly was the procedures. You'll learn in your trusts and estates class how all of the estate procedures were changed as of yesterday. They finally went into effect. It was supposed to be December 31st, but they weren't ready, so they pushed it back 3 months to March 31st, and that, of course, was a Saturday. So for all practical purposes, the courts, as of yesterday, are supposed to be implementing the Uniform Probate Code. But the guardianship part of it went into effect a few years ago, changed the way all of the papers are done. And so one of the things that it did, though, was it gave the courts the discretionary power to appoint lawyers for children in guardianships. And I don't think it's been done a lot or across the board, but if there's a particularly contested guardianship or an older child or something, the court now can appoint a lawyer to represent the child in a guardianship. And this is new because previously you could only do it if the Department of Children and Families was somehow involved. And many guardianships have no state involvement, no DCF involvement. Many guardianships are done just privately. A grandmother goes into court and asks for guardianship of their grandchild, and that's an uncle goes into court. The parents are there, the potential guardians are there, but there's no, like DCF, no big state case involved in it. But now at least the child is able to get a lawyer if the judge feels that the child needs one. The juvenile court is dealing with all of the impact of the new marijuana law. I don't know if you guys hang out with kids at all, but it certainly appears that more kids are smoking marijuana now that it's not quite as illegal. It's a little more like alcohol in that respect. But there was a case decided by the SJC recently that said even if you have less than an ounce of marijuana, you still could be charged with possession with intent to distribute that marijuana if you were going to hand your marijuana to a friend, or sell it, or deal it, or distribute it. And if the Commonwealth can prove that, you still, even if it's less than an ounce, you still can be charged with possession with intent to distribute and convicted of that, which wasn't clear from the way the new law was worded. So again, that's just more work for lawyers on really stupid cases, because it's really, it's really stupid. And the district attorney's offices are sometimes just amazing with the things that they can think to prosecute. But I always think of it as more work for defense lawyers on really stupid cases.
My favorite is the disturbing school assembly.
Disturbing school assembly, yeah. Someone has a nutty in class and they call the police and arrest them and take them out and bring them to court. Yeah, really helpful. It really, really does a great emotional job on the children that are being arrested. Yeah, it's really helpful. One of the things, if you ever get a chance, Governor Patrick instituted the Office of the Child Advocate. Former Judge Gail Garringer looks at systemic systems having to do with children, systemic problems, and comes up with potential solutions. And it's kind of like an inspector general looking over the child welfare system. And you can go online.
How big is her office now? I mean, in
What?
terms of staff.
It has like 3 people on the staff. It's really small, but she can write reports, she can subpoena people, she can look into things, so it has the potential to be interesting. She issues reports every year. She issued a report on the guardianship of minors law, and she looks at various things DCF is doing to think about whether there's ways to do it better. DCF did recently revamp totally the way it deals with 51As and made it a little more flexible. And my limited experience with it is that it seems to be working, and it seems to allow the social workers to be a little more flexible in how they deal with families. The old way of dealing with 51As is they would come in and within 10 days they had to say either you're guilty or not guilty, and it kind of went from there.
So what happens now?
Now the social workers have a little more ability to say, I don't really care if you're guilty or not guilty, but we're going to be involved with you and maybe help you a little bit. So you don't have to brand you with that abuse and neglect brand.
So they don't have to find reason.
They don't have to
That's
find
great.
abuse and neglect and label you a perpetrator and put you in the perpetrators registry, and they have a little
That's
more
awesome.
flexibility as to how to handle things. And the nomenclature's changed a little bit, and so it's not quite so bad, and so and they can be involved on a more informal level for a longer period of time without making it this huge, big case.
Does that have to be voluntary on the part of the
Doesn't
parents
have to be.
Okay.
It doesn't have to be. On some level it might be, but on some level it can be driven by 51A reports, so that the state has to be investigating them and looking in on them, but doesn't necessarily, the next item doesn't necessarily really have to do with juveniles all so much, but there's a lot of work being done on all kinds of forensic evidence questions that have to do with the courts. And what evidence is proper, what evidence can be brought to court, and in juvenile court there's a lot of avenues where defense lawyers can really fight evidence that seems to be not based on any kind of science or any kind of law. And so a lot of what we are doing as defense lawyers in juvenile court is thinking up creative ways of fighting bad evidence and stupid evidence, and the National Academy of Sciences report is really helpful in that respect. If you have a criminal law class, I'm sure you can talk about that a lot, but it comes in juvenile court as well. One of the things that the juvenile court has stepped up and about a year ago tried to address is the extent to which juveniles are shackled in the courtrooms. Up until a year ago, if a juvenile was being detained in DYS or had been arrested on a warrant in the chins, when they're brought into court, they would have handcuffs and full leg irons on their legs when they were walked into court. And any of you who have been in juvenile court probably have seen that. A year ago, on his own, really, before getting sued, the chief judge of the juvenile court, Judge Edgerton, decided that that didn't make a lot of sense. And that at least when they were in the courtroom, the handcuffs and the leg irons should come off the juveniles, and they should be able to be in the courtroom without having shackles on them. And there still is the ability to make a case-by-case determination. If you have a juvenile that you know is a runner or is some other kind of security risk, you can have some restraint on them, but the general rule is that juveniles, when they're in any kind of courtroom, should not be shackled. And that's a good improvement on the way things were. It still is bad that chins kids get shackled at all, but they do get handcuffed, they do get leg irons put on them, even though they've committed no crime. They're not charged with committing any kind of crime. They're really just the subject of a civil custody case. But the security conscious post 9/11 Homeland Security mindset is that anybody who's been arrested has to be treated a certain way. The Supreme Court yesterday decided that even the minimal kind of arrest, you can be strip searched when you go to jail or when you go to prison. So that's the kind of theory that allows juveniles, even chins kids, to be handcuffed and shackled. One of the big problems that we've tried to address in the last few years as a system is what happens to 18-year-olds who come out of DCF, come out of foster care, and have nowhere to go, no family, no support. So the federal government and the state government have stepped up to provide services and funding for foster children when they age out. There's a new law that allows the court to remain involved with these children and to have reviews, permanency reviews, even for children over age 18 to see how they're doing, to make sure that they're doing okay, and to review their situations, and to make sure that they're still getting help from DCF. So there's some improvements in that area. It's recognized to be a huge problem. You think about yourself or your kids when they turned 18, how independent were they? How able were they to run their lives? And you expect a foster child who's had nothing, the minute they turn 18, to all of a sudden be an independent adult without any help, and it's totally unrealistic. And so finally, I think there's been some recognition of that, some attempt to help them out. Even in difficult budgetary times, some of that funding is still in place, so it's a good attempt to help in that respect. It's still a problem, but it's a little bit better.
And there's a new department now in the juvenile court that's going to be involved.
It's just the same judges and the same probation officers and clerks and everything.
I mean administratively, under Judge Edgerton.
Okay.
And Maria Fournier, who used to be DCF,
Yeah.
is involved.
Helping that, yeah.
Involved in that, yeah.
I think they're just making sure that those cases get heard and
Right.
done, and that the judges are on top of them, and make sure that the kids don't fall through the cracks.
And that the kids actually come.
The kids are supposed to come to court, talk to the judge, let the judge know how they're doing, if they need any help, if they...
Because that was a big thing for years, the 29Bs.
Yeah.
Typically didn't see, the kids themselves who were, they're the ones that were aging out of the system and had huge issues, and would be just a rubber stamping, right?
Right.
For years, these reviews, supposed reviews, were like really nothing. So now there's something.
They're trying to get the kids to be more involved and to come to court, to help them out more in that respect. Rolling care and protection trials is what the way I refer to the way that care and protection cases sometimes, when they have to go to trial, in the probate and family court, the judge tries to block out. If the trial's going to be 4 days, they give you 4 days, and they say, these are your 4 days of trial, and this is when it's going to be. In the juvenile court, because the scheduling is a lot more messed up, they would make you come to court for trial. Say your trial is Tuesday, April 4th. You'd start the trial, and then the judge would look at their calendar, see when they had an open day next, and it might not be till August. So you'd come back for day 2 of trial in August, day 3 of trial in December, and then maybe if you're lucky, day 4 next March. So your trial would be over the extended course of like a year, and would never be ended, would never be decided. And Judge Edgerton, again, in an attempt to stop that, has told all of the judges that once they start a trial, they have to finish it within 30 days, calendar days. So it's forced the judges to revamp their schedules.
Order?
That's a standing order of the juvenile court, that once a care and protection trial starts, it needs to finish, the taking of evidence needs to finish within 30 calendar days. And so it has totally revamped the way most judges schedule themselves, and so they, and then there's certain time frames they have to issue their decision within a certain number of days after that, just an attempt to get the cases heard and decided more quickly. Really exciting decision for juvenile defense delinquency lawyers. Last month, Commonwealth versus Magnus M. decided that the juvenile delinquency law, even after a juvenile's been convicted in a jury trial, the judge still has the option of continuing that case without a finding and putting them on probation and allowing their record to be somewhat less serious. For adults, you can't get a quaff if you've had a jury trial or sometimes even a bench trial, but the way the juvenile court delinquency statute is worded, it gives the juvenile court judges the authority to continue cases without a finding even after you've had a jury trial. So there's almost no reason now not to have a jury trial in juvenile court if you have a case where there's a reasonable doubt as to whether your client did what they were accused of. You don't lose much by going to trial. And so hopefully we'll see more jury trials in juvenile court. Massachusetts is one of the few states that give juveniles the absolute right to have a jury trial in a delinquency case. Many states, because juvenile delinquency cases are not criminal cases, they don't give them jury trials. You only get a judge trial or a bench trial. The fact that our state gives juveniles the right to have a jury trial is a wonderful due process, but as a matter of practice, there are not a lot of jury trials in juvenile court throughout the state for a lot of different reasons, but hopefully this decision eliminates one of those reasons and will allow the court to give good dispositions. Even if you go to jury trial and lose, you still have a shot at getting a very good disposition from the court.
But how does a juvenile get to be tried by a jury of his peers?
You can't be peers. You're tried by a jury of your adult peers.
Yeah.
Yeah. But it's still better than leaving it up to a judge all the time to decide. A lot of judges are good, but a lot of judges you wouldn't want hearing your case, and even just getting 6 random people in or 12 people on a youthful offender case, you've got a lot fairer shot with the jury than you do with the judge many times. So the fact that even if the jury finds you delinquent now, that the judge can still quaff the cases is a wonderful decision, and I think it's a correct decision because I think that's the way the juvenile delinquency law is worded, and that it always has allowed judges to do that, but now it's clear. The other new law that was just passed in February was the new Sex Trafficking Law in Massachusetts that was passed and went into effect in February, that is meant to totally change the way that the courts and the state handles prostitution, real recognition that many women are put into the sex trade against their will and should be treated as victims more than as criminal defendants. And for juveniles or 17-year-olds who are arrested for engaging in sexual conduct for a fee or common night walking, there are attempts to treat them as victims, treat them as chins or care and protection cases, divert their criminal cases out of criminal court, and give them services and help, try to get them away from their pimps, and try to improve their lives in that way. This is another law that we'll have to see how it's implemented and how it works in practice. In theory, it's a great thing, but again, when you have victims of sexual trafficking, many of them don't see themselves as victims. They may not be receptive to services, so we'll have to see how it works out. But it's an interesting new law, added a new category of chins, suggested that some kind of chins or C&P should be filed on every young person who's arrested for one of these offenses, so we'll have to see how it works out. Those were the few things that I see coming up in juvenile court a lot in the last few years, and that are in the works in terms of new laws. So I hope you found it interesting. Any questions? I gave you my contact information in case you ever want to get in touch.
I have one. I just on a brief, make sure I'm certain on this one. The CHIN's reform to increase the age to 18, is that to the 18th birthday or until the end of the 18th year?
There's two different things. The CHIN's reform is just for child in need of services, and that's just for, and that leaves most CHIN's things up to age 17. The only thing that might change, that I didn't put down here, was the talk about raising the dropout age to 18. It will be interesting to see. It looks like that might happen. I think it's already happened up in New Hampshire, but New Hampshire did away with CHINs entirely. There's no CHINs law in New Hampshire anymore. They just wiped it off the books last year, so. But if Massachusetts raises the dropout age to 18, it will be interesting to see if they make the CHINs age 18 too. All of these would be only to the actual 18th birthday, because that's when people become adults. That's when they do it. The other, raising the age of juvenile court to 18, the other, that's for delinquency cases, or for kids getting arrested. And it's that law, that change would cover 17-year-olds who are arrested for committing a crime. They now go to adult court. The theory of this new law is that they would go to juvenile court instead, and the juvenile court would deal with their cases. And the cutoff there is if they commit the crime when they're 17, then they would go to juvenile court instead of adult court. That's the age cutoff for that. There are provisions in the law that, because cases take a while to be decided, they may turn 18 while their cases are being decided. The juvenile court keeps jurisdiction of the case and of the probation until they're 19. And that just gives the court time to figure out if they're guilty or not, have their jury trial, put them on probation, send them to UAS, whatever it might be. So that, all those age ranges might increase or might change around, but it's different for CHINs than it is for the delinquency cases. And how they work. That's a good question. Yes?
So, I'm confused, as usual. So, you said the juvenile court isn't criminal court. Is that what you said?
Well, that's a theory, like you said, that's the theory.
But if
that,
they're charged with a crime and
Yep.
they're gonna get put away,
Yep.
isn't that?
Well, they're committed to the Department of Youth Services, which is not a jail, supposedly. It's a confinement, juvenile hall, or whatever you might call it. They're not able to go to Middleton House of Correction or Billerica House of
Which some
Correction
of you
or
are gonna see
wherever.
on Friday.
Yeah, yeah, so that, and they're supposed to be treated as youth who are in need of correction rather than adults who are in need of being sent to jail. It's a weird mix of things.
It is.
A
I mean,
fine line.
even,
Yeah, it's a
yeah,
very
Leslie,
fine
even the
line.
statute that includes the youthful offenders still says today that they treated it in need of aid, encouragement, and guidance, something
Yeah.
like that. I think
Yeah.
I'm quoting from that.
Yeah.
That these are not criminal proceedings.
They'll walk
Right.
away.
But,
Right.
yeah, their liberty is taken away.
Right.
Yeah,
Right.
yeah.
Well, that's why they get lawyers, that's why they get jury trials, that's why they get all the other due process protections. So it's a weird mix,
Yeah.
combination of things.
And when do they put them in, like, go with the House of Correction?
Only
What's the
17.
after they turn 17.
After 17.
Yeah, so you'll be going
In
to
some
district court.
situations, in some situations. In some situations, if they're being locked up for something that they did before they turned 17, or if they're violating their juvenile probation, DYS will still take them. And if they're youthful offenders, they're on probation till they're 21, DYS will still take some of them too. So it depends a little bit on the circumstances, but anyone under 17 has to go to DYS. Some 17-year-olds go to the House of Correction, but some of them stay in DYS depending on what they're in trouble for.
And so on that thought of DYS, if somebody commits a crime, say they're 15, and it's a
Yeah.
horrendous crime.
Yep.
What do you mean by horrendous? Give an
Like
example.
they tried to kill someone.
Yep.
And isn't it true that they get committed to DYS, but at their 21st birthday, they're out of there no matter what?
It depends. It depends. That's the Youthful Offender Law. If the district attorney's office decides to prosecute the case as a youthful offender, they present it to the grand jury. The juvenile is indicted as a youthful offender. The case stays in juvenile court, but the juvenile court has more options in terms of sentencing. The juvenile court can decide just to commit the person to DYS to 21. Or the juvenile court can give that juvenile an adult sentence and could actually give them a state prison or house of correction sentence. They
Even
would
though
not
they're
go,
15?
they would not go to the state prison
Not
until their
initially.
17th birthday.
I see.
But they would have to serve out a full state prison sentence. And there's also a combination sentence in between those two, where they would be in DYS till they're 21, and then they would get an adult suspended sentence after that. So they would get out when they were 21, but they'd be on adult probation after they were 21 for some length of time. And I've seen people who are youthful offenders who are on probation as an adult until their 25th birthday, say. So they will be in DYS till they're 21, will be supervised by DYS, because DYS can parole kids too. They don't actually stay in a locked DYS place until their 21st birthday. They can get paroled by DYS and supervised in the community, and then they would be supervised by DYS till their 21st birthday, and then supervised by adult probation until the court thinks it's no longer
Are
necessary.
DYS centers co-ed?
No. Separate for boys and girls. And that's a whole other question. What if you have a lesbian, bisexual, gay, or transgendered youth who gets involved in DYS? Do they put him in the boys or the girls unit? But that's a whole other issue. But no, they're totally separate. The one juvenile detention facility for girls in Boston is in the same complex as where the boys are, but it's in a completely different wing, and they would never see each other.
What's it called?
Metro, DYS Metro on Harvard Street in Dorchester. The girls' Spectrum unit is in the old run-down part of the complex, and the boys are in the new part of the complex on the other side, where the real bars and locks and everything else are. So,
Thank you, Mike.
thank you.
Thank you very much.